That's great. Perfect.
Okay, thank you very much. All right, thank you for having us. This presentation briefly focuses on the COVID-19 pandemic and the response by several South African states to it. In particular, it examines the dual obligations imposed on states during public emergencies, both from the domestic law and international law perspectives. And it also specifically seeks to ascertain whether some of these obligations have possibly and on an occasion been avoided. By now, the drastic response by states in tackling the pandemic is nothing new. One common response that we have seen in tackling the pandemic seems to be the declaration of a state of emergency. And globally, no less than 24 states have made such declarations. On several occasions, though, other declarations or designations have been assigned to the COVID-19 pandemic, which we will turn to shortly. The most notable effect of declaring a state of emergency is, of course, the permissibility of states to derogate from their human rights obligations. This derogation is usually regulated under both domestic law of states, but also under international treaty law. Now, the following slide gives us a brief overview of the states' responses from Angola to Zimbabwe on the kind of responses we've seen from Southern African states to the COVID-19 pandemic. And looking over this, we can make just a few observations. Now, the first one is that several Southern African states have indeed resorted to declaring states of emergency. It includes Angola, Botswana, Eswatini, Namibia, and Lesotho. Second, some of the responses by the states have had some gradual effects. So Angola is a good example where initially they opted for a state of emergency, but from May onwards, they've sort of downscaled this response to what they've designated as a state of public calamity. And a third observation we can make from these responses is that some states have actually not resorted to declaring states of emergency at all. They've opted for other sorts of declarations or designations. From that, we see specifically Malawi, Mozambique, South Africa, and Zimbabwe. Now, these other designations are what are of particular interest to us for our study. And the reason for this is that primarily that on occasion, these designations can impose a de facto suspension of rights, but without the normal checks and balances that we usually see under a state of emergency. One example here is Angola. Angola declared, well, they first declared a state of emergency, but shortly afterwards, they declared a state of public calamity under Presidential Decree 142 on 25 May. And this was done in line with its law on civil protection. Now, some of the impacts of this designation of a state of public calamity include the regulation of educational institutions, including their closure, traffic affairs, the movement of citizens, regulation of places of worship, the compulsory provision of individual healthcare. In other words, citizens may be forced to undergo a certain healthcare treatment protocol, and a temporary occupation of private and public immovable and movable properties. South Africa is another example of this. Rather than declaring a state of emergency, it declared a state of national disaster. This was generally perceived as a serious de facto suspension of some constitutional rights guaranteed under the South African Constitution. Now, beyond those points just raised, the general observation that we can make with some specific rights, other than the ones we mentioned, includes, for example, the freedom of movement, freedom of choice, the right to freely practice religion, and even the right to peaceful demonstration. Now, it's worth noting that in contrast to these states, other states such as Namibia, Mozambique, and Lesotho were explicit when they made a state of emergency, to the extent that they made these states of emergency under their constitutional provisions, and therefore the derogation of rights was also regulated under their constitutional provisions. One example here was Lesotho, where there was an attempt to extend their state of emergency by 6 months. But this was eventually rejected by the National Assembly, which is one crucial check by the legislature on that state of emergency. Now, the previous slide outlined the relevant state responses. Now, the following were just to address some basic considerations on the domestic legal framework around states of emergency. First of all, what we need to note is that all the states considered above are constitutional states. Therefore, they're based on constitutional supremacy. Now, their constitutions also spell out explicitly the process of a state of emergency. There are a few characteristics that are worth noting. First of all, it's an executive declaration that needs parliamentary approval, as opposed to many of the other designations that don't need parliamentary approval or any oversight from the legislature. States of emergency are usually also subject to time frames, often 21 days. Another common characteristic that is found here is that they often need a larger threshold when they need to be renewed compared to when they are first imposed. Now that can be usually anywhere from a 2/3 majority and higher threshold. And of course, most importantly, the constitutional provisions that provide for the states of emergency also explicitly outline the derogation of rights. Now, tied in with this, of course, these constitutions also impose international treaty law obligations. That is to say that the state has constitutional obligations, but also because of their constitutions, these constitutions explicitly impose international obligations on states, most notably, of course, international treaty law, which states have duly ratified. Now, for our purposes, there are two treaties that we're looking at. The first, all of these have been ratified or acceded to by the states in question. Now, the first one is the International Covenant on Civil and Political Rights. Article 4.1 primarily regulates the position of public emergencies. Those that are officially proclaimed, at least, allow for the derogation of states to derogate from their obligations under the covenant. Interestingly, the impression that states have of this provision is that only a state of emergency allows for derogation. Hence, their constitutional provisions allow for derogation in combination with the declaration of emergency. What this ultimately means is that if rights are, the suspension of rights is not contemplated under any other designation except for state of emergency. By implication, what this means is when another designation is undertaken, it is assumed that it is not actually a suspension of rights, but rather that it is a constitutional limitation on those rights and nothing close to a suspension of the derogation of those rights. Now, the other relevant treaty for our purposes at the moment is the African Charter on Human and People's Rights. Again, interestingly, the African Charter has no derogation clause, and this has led to two predominant interpretations of Charter. The first one is that because it has no derogation clause, derogation is therefore not permissible. Now, one other interpretation, which I think finds better application, is the silence of the Charter's position on derogation of rights means that it fails to set out any standards of conduct. And where we have a de facto suspension of rights, there is no repercussion to such a situation. Now, with all that has been said above, and we're having all of this in mind, this leads us to a number of questions, particularly questions arising to the responses of states during this COVID pandemic. That is, first one is, what is the situation in which a formal state of emergency is not declared? Of course, this is the big question because, as we've seen, several states have avoided declaring state of emergency. And this may be one reason is because there are additional obligations imposed should they follow that route. Notwithstanding that alternative declarations or designations seem to de facto suspend rights, should the designations such as a state of national disaster or even a state of public calamity be subject to the same checks and balances as state of emergency, especially if we consider that these other designations also to some extent suspend constitutional rights, and should they also not be held to a higher threshold such as threats of emergency? And these higher thresholds, of course, include the constitutional obligations, but also international treaty law obligations. And in concluding, at present, it's quite clear that the different states have different approaches to how they've handled the pandemic. What is, however, very certain is that their constitutional obligations remain. Even if they declare states of emergency, they will always have some sort of constitutional obligations which they will need to adhere to, even under states of emergency. So states' obligations include that it is taken in line with the relevant international and regional treaty law legislation. We are very well aware that they've bound themselves to the relevant international treaties. and therefore these international law obligations are in addition to obligations that these states already face under their constitutional dispensation. In considering those obligations, it seems that the present state is that the state practice suggests a great focus on the actual designation or declaration, or what we can consider as the formal determination of a situation, to ensure the compliance with both the constitutional provisions as well as the international obligations of these states. Focus should perhaps be directed rather at the content of these declarations or designations, and especially its impact on human rights. That is to say, whether there is in fact, a suspension of the constitutional rights rather than an argument that they are just constitutional limitations. Thank you very much. That concludes the presentation.